5 seconds to go. Start. However laudable the object of the donor may have been, the gift has to fail because the genuine attempt of the donor to benefit his granddaughter seems to have been thwarted by the intervention of subsection 6 of section 5 of the Act. This is undoubtedly a serious hardship, but it cannot be helped. We must remember that the Act is a valuable piece of social legislation with the avowed object of ensuring equitable distribution of the land by taking away land from large tenure holders and distributing the same among landless tenants or using the same for public utility schemes, which is in the larger interest of the community at large. The Act seems to implement one of the most important constitutional directives contained in Part 4 of the Constitution of India. If, in this process, a few individuals suffer severe hardship that cannot be helped, for individual interests must yield to the larger interest of the community or the country, as indeed every noble cause claims its martyr. Though the court found that the act caused a serious hardship, it held that the act is a valuable piece of social legislation. It held that the act was enacted to implement one of the most important constitutional directives contained in Part 4 of the Constitution of India. It further observed that if in this process a few individuals suffer severe hardship that cannot be helped, it further held that individual interests must yield to the larger interests of the community or the country, as indeed every noble cause claims its martyr. In any case now, the action which was taken by the central government by the impugned notification has been validated by the 2016 ordinance and which has fructified in the 2017 Act. The central government is answerable to the parliament and the parliament in turn represents the will of the citizens of the country. The parliament has therefore put its imprimatur on the executive action. This is apart from the fact that we have not found any flaw in the decision making process as required under subsection 2 of section 26 of the RBI Act. The decision making process is also sought to be attacked on the ground that the decision was taken in a hasty manner. We find that the hasty argument would be destructive of the very purpose of demonetization. Such measures undisputedly are required to be taken with utmost confidentiality and speed. If the news of such a measure is leaked out, it is difficult to imagine how disastrous the consequences would be. It will be interesting to note again from volume 3rd of the History of the Reserve Bank of India that on 14th January 1978, one R. Janki Raman, a senior official in the RBI, was asked by some officers of the Government of India to come immediately to Delhi for some urgent work. When he asked for what purpose he was called, he was told that the matters relating to exchange control need to be discussed. He, however, took along with him one M. Subramaniam, a senior official of the Exchange Control Department. On reaching Delhi, he was informed that the government had decided to demonetize the high denomination notes and was required to draft the necessary ordinance within 24 hours. During the said period, no communication was allowed with anyone, including the bank's central office at Bombay. R. Janki Raman and M. Subramanian made a request for the 1946 ordinance on demonetization to get an idea how it was to be drafted, which request was acceded to by the finance ministry. The draft ordinance was completed on schedule. It was finalized and sent for signature of the President of India in the early hours of 16th January 1978, and on the same day the announcement to that effect was made on All India Radio's news bulletin at 9 am. It can thus be seen that confidentiality and secrecy in such sort of measures is of paramount importance. When demonetization was being done in the year 1978, R. Janki Raman, who had drafted the ordinance, was not permitted to communicate with anyone, including the bank's central office at Bombay. It would thus show as to what great degree of confidentiality was maintained. In any case, the material placed on record would show that the RBI and the central government were in consultation with each other for at least a period of 6 months preceding the action. We therefore find that the impugned notification dated 8 November 2016 does not suffer from any flaws in the decision making process. As to whether the impugned notification dated 8 November 2016 is liable to be struck down applying the test of proportionality, it is so to be urged on behalf of the petitioners that before taking such a drastic measure, which caused enormous hardship to a number of citizens, the government ought to have found out as to whether there was an alternative course of action which could have resulted in lesser hardship to the citizens. In this respect, reliance is placed on the judgment of this court in the case of Internet and Mobile Association of India Supra and K.S. Putaswamy retired and another Supra. Stop.